IVM.
Hey guys, IBM Podcast is turning 7. Can you believe it? It's been a pretty awesome journey for us with these wonderful folks, and I can't wait to see what the next 7 years bring.
Welcome to All Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hi, I'm Sarthak and I welcome you to one more episode of All Things Policy. In this episode, I have with me my colleague Apurva, and we are going to talk about the Article 21 of the Indian Constitution. This episode heavily draws from the book that we have been reading. The book is Liberty After Freedom, A History of Article 21, Due Process and the Constitution of India by Rohan J. Alva. We'll share the link of the book along with this podcast episode. Please do check it out. Hi Apurva, welcome to yet another episode of All Things Policy.
Thanks, Sarthak. Thanks for having me.
Yeah. So before we start, I would like to quote what is there in Article 21. Right. So if you look at the Indian Constitution, it is divided into different parts. The third part of the Indian Constitution talks about different fundamental rights. One of those fundamental rights is enshrined in the 21st article, the Article 21. Article 21 says, no person shall be deprived of his life or personal liberty except according to procedure established by law. And this particular right is available to both citizens and non-citizens. So before we discuss about the provisions of Article 21, I think it makes sense to discuss about how this article has evolved, or in fact, we can step back. And as Apur, we are talking about how there were different kinds of differing viewpoints about this article in the Constituent Assembly debates. So, Apur, would you like to add something to this?
Yes, so I think this is one of the most important article of the in the Indian Constitution, Sarthak, because many fundamental rights, in fact, many progressive rights, and later on several progressive judgments, they sort of hark back to Article 21 because of right to life and personal liberty. Right, for example, right to privacy, right, and repealing of Section 377, decriminalizing homosexuality. So that is why in 2017, there was a famous case in Supreme Court called Nikesh Tarachand Shah versus Union of India, in which the Supreme Court actually said that Article 21 is the ark of the covenant so far as the fundamental rights chapter of the Constitution is concerned. So basically, they said that this is one of the most important articles. Right? And it is very important to understand the history, the evolution of this article, because I think this was one of the few articles in section in the Indian Constitution that was rigorously debated in the Constituent Assembly debates. These debates, and you have rightly sort of quoted Rohan Alva's book Liberty After Freedom, because he has sort of tracked the history of the evolution of this article. Like, and there were like several phases through which this article evolved. There was a phase from 1946 to 47, 47 to 48, then 48 to 49, 50 when we had a constitution, and then it took like a good sort of 2 decades to sort of reform and kind of rephrase article. Now let me begin from the very beginning. So I mean, as you would know that the first charter of the constitution was proposed by Pandit Jawaharlal Nehru, and this was known as objective resolution, right? And objective resolution was a very common and a generic sort of a document in which he basically talked about the relationship between the states and the union, about the rights, protection of minorities, so on and so forth. But these are not prescriptive. These were just sort of ideas. These are just good ideas. So when after that there was advisory committee that was formed. Within advisory committee there were other subcommittees. So there was a subcommittee on fundamental rights, and it was this subcommittee who later on sort of started debating on these rights on Article 21, and a very important section of this article, Sarthak, which was the due process component, right? The second part of article which you just said, that no person shall be deprived of his life or personal liberty except according to procedure established by law. This, I think, these 5 or 6 words actually became the bone of contention, right? And two stalwarts, K.M. Munshi and Aladi Krishna Swamy, one of the finest legal brains of India, During those times, they debated along with others on the pros and cons of this. Right now, coming back to objective resolution. So objective resolution was passed, but Dr. Ambedkar realized that although these are like sort of good kind of ideas, these are good ideas, but the enforceability or how the due process will be followed is completely missing. And then the sort of role of putting up some more details and enforceability details and due process details was shifted to the subcommittee of on fundamental rights. So when this subcommittee sort of started its deliberation, they added something, they added a phrase which was very much on lines of US Constitution. And they said that no person shall be deprived of his life or personal liberty. They also added property at that time, without sort of, due process of law. Now they added due process of law, and all the members of that subcommittee, especially Mr. Munshi and Aladi Krishnaswamy, they sort of, rigorously defended the rationale of putting due process, because what would happen is that if you don't add this due process clause, the legislature can pass any law that can actually deprive your liberty and freedom, right? So the legislature can tomorrow pass a law that will sort of, that will institutionalize illegal detention. And just because it's a law and it's not sort of articulated in the constitution, you cannot sort of challenge it, right? So that was the rationale. That is why they added due process of law. Now, what happened was, I mean, this was debated. Due process of law was sort of, taken in the draft by the drafting committee, so on and so forth. But something happened in 1947 and 48. I think B.N. Rao, who was one of the best sort of legal advisor and, legal luminaries, who was also part of all these deliberations of drafting committee, somehow he realized that due process of law would sort of shift the power too much on the judiciary, which are the unelected set of group of people rather than legislature. So I think that this is what Rohan Alva says in his book, that deliberations during that time is not very clear. Why? So some for some reason due process of law was removed from this article Sarthak. So I think this was something which is perplexing, that why it was removed. So when this thing was shown to the Constituent Assembly members as well as to the drafting committee members, they were surprised and concerned why there is no due process. Right. And then there was, again, a rigorous round of debates. But I think that set of people prevailed. And it was at that time when, interestingly, Aladi Krishnaswamy and K.M. Munshi, who were sort of, collaborators, when this clause, due process clause was added, they sort of parted their ways, right? So K.M. Munshi, who was, pro civil liberties, he argued and advocated that due process law should be included, whereas Ladi Krishna Swami said that due process should not be included, right? So it went on. So, Constitution, we adopted the Constitution in 1950. I think later, after several years, after a couple of decades, the Supreme Court and, the judiciary realized that, some amendments need to be made. And that's why we have the current clause, which says according to procedure established by law.
Yeah, so yeah, exactly right. So you have explained the history behind this, history behind the usage of this particular term, right? So procedure established by law basically allowed the legislature to pass laws, but these laws can violate individual civil liberties. But in due process, if the term due process had been there, in that case there would have been another check somewhere. So in that case, the judiciary would have the right to protect these liberties. The judiciary can actually question some of the laws if they are not just, if they are not reasonable, if they're violating individual liberties. But maybe, I mean, members of the judiciary are also drawn from the public. They might also have some prejudices. They are unelected. So maybe at that point of time, they would have there would have been some apprehensions in the Constituent Assembly among the members of the Constituent Assembly, and they would have gone ahead with procedure established by law.
Right. So one more thing, if I may add, these two phrases, procedure established by law and due process. So even what to use, the language of this article was also rigorously, debated. So the members were divided on whether, procedure established by law should be used or whether due process should be used. So there was a section of the members who said that if you use procedure established by law, it will allow the legislature to pass laws that would sort of violate an individual's civil liberties, and especially when it comes to detention and punishment due to in the India's criminal justice system. Whereas there was another section who argued that if they use the term due process, the judiciary would have the right to protect these liberties and they will investigate. So I think there was a lot of debate that went on, even to sort of, refine this phrase, whether they are to use due
Yeah.
process or procedure established by law.
Yeah, but it is interesting to note how the way this particular term, procedure established by law, and the Article 21 has been interpreted at different points of time, right? So, in the early 50s, in fact, in 1950, the Supreme Court in the Gopalan case, right, it had a very narrow interpretation of this, right? As per the Supreme Court judgment in the Gopalan case, Article 21 is available only against arbitrary executive action and not legislative action. So in this case, what is happening is the Supreme Court interprets that state can deprive the right of life and personal liberty based on procedure established by law. Right. So if there is a law, if a law has been set up, but this law is violating some civil liberties, this particular law still is valid. But over a period of time, this interpretation has also changed. Right. In 1978, in the Menka Gandhi case, the Supreme Court is going back. It is overruling the Gopalan judgment. And according to this judgment, right to life and personal liberty can be deprived by a law provided by the procedure prescribed by the law is reasonable, fair, and just. It is not just that you should have a law in place and the law can deprive someone's rights. The Supreme Court is saying that the law also in itself has to be reasonable, it has to be fair, it has to be just. So it is now giving some sort of powers to the judiciary now to decide the intent of this law, right? Whether this law is reasonable or not. So according to this interpretation, the protection that is given by Article 21 is not just from arbitrary executive action, it is also from arbitrary legislative action. So, over a period of time, like if we are going for due process only, right? I mean, maybe the term over there is procedure established by law in the article, but if you look at how it has been interpreted, right? So, judiciary is having some powers to interpret the law, whether it is reasonable, just, and fair.
Right, Sarthak. I think you have very well articulated, and the judiciary has interpreted this Article 21 in several ways. Let's take a short break here, Sarthak, and maybe after the break, and also talk about another article after Article 21 that actually sort of became another bone of contention, and started another set of debates. And it was then that the Constitutional Assembly members realized that they have made a mistake by not including a due process. So let's talk about it after the break.
Hello. It's been another great week on the IVM Podcast Network. On Cider Says is Cock and Bull. Cider has a great time with comedians Puneet Pania and Abhijit Ganguly. Check it out as he shares stories of his hilarious encounters with Amitabh Bachchan. On The Wire Talk, Siddharth talks to author G.N. Devi about his latest book, Mahabharatam, The Epic and the Nation. On Postcards from Nowhere, Utsav tells us an intriguing story of the Siddhis, their connection to limes and Benazir Bhutto. The Pulyabazi host talked to Nihar Shah, assistant professor at Carnegie Mellon University. They discussed how to distinguish between good science and pseudoscience. And on Ikaduka Economy, Abhinav and Dr. Junjunwala break down how interest rates are determined for loans. Do follow us on social media. We're IVM Podcast on Twitter, Facebook, Instagram, and LinkedIn. And remember, if you're enjoying this show or any of our other shows for that matter, please do tell a friend. It really helps us. Don't forget to rate us on any of the platforms that you're listening to. And also remember, you can check us out on YouTube at www.ivmpodcast.com/YouTube. And finally, we'd like to thank our sponsors this week, SBI Life Insurance, Bank of Baroda, and HDFC Life Insurance. Thank you so much for making this possible.
All right, welcome back. So, Sarthak, I was talking about another article that actually was sort of, included in the draft constitution in 1949. I'm talking about Article 22. So, Article 22 actually sets up some sort of a due process in arrest and detention cases, right? And it's a long sort of, article. So, Article 21 is just 18 words. Article 22 is quite long, is a longer article. And when this article was sort of introduced and debated, the members of Constituent Assembly, they started questioning and the very rationale of not having due process in, a right to life and personal liberty, but having due process in detention and arrest. So they say that it defeats the whole purpose because 2 years ago you said that you would not have due process, and now you are having due process, right? So I think it was in 1949 onwards when the members started to realize that they have made a mistake. And then, of course, I mean, it took longer time to sort of, have this clause or the due process clause by the judiciary. But yeah, I mean it was Article 22. There was, I think, another article in which they talk about a due process for some other reason. So using these precedents, they were questioned that why we have due process in these, but not in the very fundamental sort of right to life and liberty. So I think that also generated a lot of influx and sense of anxiety amongst the members.
Yeah, so this is interesting. Now, a couple of more things that I find while intriguing about this particular article is how wide this is, right? I mean, there is one article, but it has been interpreted in
Right.
different ways, and it actually impacts us in multiple ways, right? The way Supreme Court has interpreted it from time to time. So, for example, there are multiple terms in this article, right? Right to life, right to personal liberties, and yeah, one of those terms we already talked about, procedure established by law. So, this right to life has again been interpreted in different ways, right? So, it is not just about merely survival, it's not just confined to animal existence, so as to say, right? So every individual has the right to life. That means the person should not only be surviving, but that person should also be living a life of dignity, right? All those things that are required to make a person's life meaningful, complete, worth living, all these things are covered within the ambit of right to life, right? So if, let's say, there's a person who is surviving, but his body is being mutilated or destruction, or his organs are being destroyed, right? All these things are violation of right to life. And I mean, this is something which is very at a very basic level, but then there are wider connotations of this as well. For example, the Supreme Court has interpreted that the right to a decent environment is also part of right to life. Because
Right.
if you do not have the right kind of environment, let's say the environment is polluted, water is polluted, air is polluted, all these things have a bearing on an individual's living standards. Maybe all these things might poison an individual, all these things can reduce the life of an individual's. So right to a decent environment, right to a life free of pollution, water pollution, air pollution, all these things have been interpreted as part of right to life. Also, right to shelter has been interpreted as part of right to life, because if you do not have a proper residential place, if you do not have shelter, then your opportunities to grow physically, mentally, intellectually, all these things can get hampered. Right. So all these things are kind of interesting. Right to a life of a right to living with human dignity. Individuals should have the right to live in peace, sleep in peace. Individuals should have the right to reputation, because good reputation is considered to be a very important element of personal security. So the way right to life is interpreted and how different laws have followed from this, right? Other laws have followed from this. The state might have made multiple kind of laws which impact us in our everyday existence, right? That makes it interesting.
Yes, I mean, Sarthak, I mean, imagine in the famous Puttaswamy judgment, in which right to privacy was sort of declared as fundamental right. Even they evoked Article 21 because the whole sort of thing rests within Article 21, right to individual privacy. And imagine this is 2017, sitting in court, room number one in the Supreme Court. The nine-judge bench has started, the summer of 2017, and the nine-judge bench has started deliberating and hearing and discussing about right to privacy, which was something which was not even talked or unheard in Indian landscape, right, and Indian society. But a 70-year-old Article 21 that has gone through several rounds of deliberations, heated debates, disagreements, and agreements, I think that article was evoked for right to privacy, and that shows what kind of legacy and what kind of significance this article has.
Yeah, exactly. And there's another case I'm getting reminded of in the Vishaka versus State of Rajasthan case,
Right.
right? There also, the Supreme Court declared that if there is sexual harassment happening against women at workplace, this is violative of right to life. Again, this is also violative of Article 14, Article 15, equality and all, but it
Correct.
is also violative of right to life. And accordingly, the Vishaka guidelines followed. And eventually, laws were also made to prevent sexual harassment at workplace. So this particular article has very wide connotations.
That's right. That's right, sir.
So Apur, do you have any closing comments?
Yes, Sarthak. I think this is very important, not only to look at, how what kind of stand judiciary has taken over the past few decades on Article 21, but also, as I said, in the beginning, and what Rohan's book also talk about. So it's a history of this article, the evolution of this article, the intellectual debates around this article that is extremely important. and true to the very character of Indian Constitution that provides separation of powers between the various wings of the state. I think Article 21 also tries to sort of bring that kind of check and balance mechanism to law making capacity of the legislature, right? And that is why you have a due process clause. I would just like to close what Ambedkar said in 1950, that this is what he hoped, that the people charged with working the constitution would be respectful of due process rights, regardless of its absence from the text of the constitution. So at the end of the day, he said that it should be a part of our DNA and of our thought process, rather than sort of arguing on whether it's there in the text or not.
Yeah, so interesting way to end this conversation.
Right.
So thanks, Apurva. Thanks to the listeners for tuning in. We'll meet again in another episode of All Things Policy. Thank you.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.
Habits? Routines? How exactly do they help us get better? Well, to simplify it for you, tune in to the Habit Coach podcast. I am Ashton Doctor, and I'm going to be here to help you get better daily with some simple, easy-to-do habits that you can easily adapt to your life. So tune in to the Habit Coach podcast from Monday to Friday, because I believe that awesome lives start with awesome habits.
Love fighting?
We've got you covered.
Check out our show, The Fighting Goat, where we, the voices of the internet, Arjun Chipalkatti and Somesh Kamra, bring to you crazy weekly action on your favorite combat show, The Fighting Goat.
Be it commentary, breakdown, predictions, analysis of styles and techniques.
And of course, your round of favorite fighters.
You can listen to us every Thursday on the IBM Podcast app, website, and all major podcast streaming platforms.